All right, we're going to start our afternoon. In my infinite wisdom, I set two difficult cases for the same time, thinking one of them would resolve. At this point, it is not. So we're double booked for 1:15, and we'll see how it goes. It's not actually here. Good afternoon. I'll put you in the waiting room. You're in the right place. All right, that's the Terminator company lady, I believe.
That one, that's 13 pages. It's nothing but a repeat of the notice of hearing, and you remote for hearing. There's no document.
So the motion never got put in there?
Whatever's in there is just repeat 13 pages of notice of hearing and remote hearing.
Well, I've got a paper copy of it.
So, yeah, so that's not scanned in there, and that's not the attachments that's in there.
All right, I'll just use the paper
Okay,
copies.
then she'll need to put them in afterwards.
All right. Thought I was crazy. I couldn't find my good morning or afternoon. I couldn't find the documents in on base. Good afternoon. Mr. O'Donnell, can you hear me? Good afternoon, Mr. Soltis, can you hear me?
Yes, Your Honor. Good afternoon.
Ms. Amato, can you hear me?
Yes, Your Honor, I can, and unfortunately, it's not letting me turn my video on.
Okay. Mr. O'Donnell, Ms. Bowers, can you hear me?
Yes, Your Honor.
All right. And Ashley's here on behalf of Pine Valley Place. I have here with me in the courtroom a couple of the witnesses in that case. Ms. Amato, have you and Ms. Bauer been talking?
No, Your Honor, we have not.
She's been here all morning. I'm not sure what the status is. Defendant would not be. All right, well, let's take up a matter that we'll do first. I've double booked the day because I thought Pine Valley and Stroop was going to resolve. According to Ms. Bauer, it is not resolved. And we're on track for a knockdown, drag out termination of tenancy hearing. I've got Mr. Soltis here on behalf of Rosemary Blair, and Mr. O'Donnell and Ms. Bowers are here in pro per regarding that attorney's motion for contempt. Ms. Amato is here. She can't turn her camera on. Do you guys wish to touch base in the breakout room?
Well, I attempted to call Ms. Amato about 45 minutes ago, and then sent her an email asking her to call my cell. I was hopeful that we could stipulate to some facts, some exhibits.
All right, well, why don't you go in the conference room and I'll put the two of you in the breakout room. I've already got the conference room entitled Meg Bauer. So why don't you guys talk a bit and I'll work on Mr. Soltis' this matter with Mr. O'Donnell and Ms. Bowers.
Thank you, Judge. I may take a trip to the
Sure.
restroom in between.
All right, Ms. Amato, I wish you could turn your camera on, but I'm gonna put you in the breakout room so you can speak with Ms. Bauer. And I'll address the other matter while you guys are doing that. That takes some of the stress off and set at the same time.
Thank you, Your Honor. I'm still working on it.
All right, well, let me open the break dancing room. Or close them all. Pamela Amato and Meg Bauer. All right, you guys should be able to talk.
Thank you, Your Honor.
Ms. Brenneman, I haven't forgotten you. The parties are discussing the matter right now in a breakout room, so I'll put you back in the waiting room. Don't go away. Ashley, I might as well put you in there too and let you work on your other stuff.
Thank you.
If they need you, I'll draw you into the room, okay?
Mhm.
All right. Ms. Bauer's not there yet. Make sure. Yes. All right, Mr. Soltis, thank you for your patience. All right, our next matter is the ongoing saga.
This isn't just a property dispute. This is a 3-year legal saga spiraling toward foreclosure. An 80-year-old property owner, a couple representing themselves, over $17,000 in unpaid taxes, escrow payments ordered by the court and then stopped. Add in tax liens, frozen bank accounts, and a trial that might not even happen. The judge already cut their escrow in half, and now he's being asked to hold them in contempt. The big question? Are they victims of financial hardship, or are they ignoring court orders? And in civil court, that distinction matters more than emotion. Watch closely, because this ruling could decide who keeps control of this lake house or whether it goes straight to tax sale.
Ongoing saga of Rosemary Blair versus Joseph O'Donnell and Carla Bowers. Mr. Robert Soltis is here for Rosemary Blair. Carla Bowers and Joseph O'Donnell are here by Zoom. This matter is embarrassingly old. The file number is 221864LT. Now we're in 2026. This is Mr. Soltis's motion for contempt for the defendant's neglecting or declining or refusing to pay the escrow fees, which I cut in half. He claims the property is essentially abandoned and asking for relief from the court. Mr. Soltis, what's your position here?
Well, my position is, unfortunately, Your Honor, we have to be back here again. And the court was kind enough to reduce the escrow from $2,000 to $1,000 back in May. June 11th is the order. And payments have not been made. And there's a number of payments that have been missed. And October, November, December, January, and February have not been paid, according to the records that I received from the county clerk. And Your Honor, we don't need to, I hate to have to come back here all the time for this, and you've been most generous. Meanwhile, up at Judge Stutzman's office, we have another case. We have the counter complaint, and the counter complaint, I gave them request to admit, a request to produce an interrogatory.
Your Honor, is this relevant?
Yes, it is.
Back in November, we had to file a motion, and we heard that was heard on January 29th. Judge Stutzman adjourned the motion on the promise by Mr. O'Donnell that those interrogatories would be answered and I'd get the documents by at least February 6th, the next week. And of course, I did not. And as we sit here today, Your Honor, I still haven't. So we have to go back to see Judge Stutzman on March 11th. These folks just don't do anything that the court and court rules require. So, Your Honor, we're asking that they be held in contempt. Now, I've checked the escrow. According to my math, not counting what's been paid, and Miss Belair is $5,000. There's $13,571.48. Taxes for 2024 have never been paid, and it's obviously going to go into foreclosure. And that amount.
Now, I released $10,000 of the escrow, but that would have paid the 23 taxes?
Correct.
Okay.
Now, the 24 taxes are now delinquent. And that amount is $9,459.82. in the meantime, obviously 2025 taxes are due. And those are $8,373.16. And total taxes due are $17,823.98. And that is more than the escrow, actually. So I guess what I'd ask, Your Honor, is that we use the escrow for the 24 to avoid the house going into tax sale, and nobody wants that. And then order that Mr. O'Donnell and Ms. Bowers pay the 2025 taxes, which are now due. Of course, I'm asking for court's attorney's fees and costs because we have to keep filing these motions, and because they won't do what the court orders. Thank you.
Well, you also asked for possession of the premises.
I do,
This
Your
should
Honor.
not take this long. We got our case done in 23, I don't know, and then it got into the circuit court and it was delayed for a year. The delay has hurt everybody. It certainly hurt the O'Donnells. It certainly hurt Rosemary Blair, who's in her 80s. And the matter is unresolved. The house's circumstances unclear. And the delay has not been good for anybody. Counsel withdrew because he withdrew. Leave it at that. They didn't get new counsel. They're trying to navigate these difficult waters by themselves. It strained their relationship. And so are you also asking that Ms. Blair have possession of the house?
Yes, Your Honor. First of all, Ms. Bowers and Mr. O'Donnell haven't lived there, I guess, ever since you gave them possession, probably, and even before. The house is going, excuse my French, to pot. They're not taking care of it. It's deteriorating, and you know it's obviously its value is diminishing by not having anybody in there taking care of the property. And so, yes, if they're not going to do what the court has ordered them to do by way of escrow and others and paying the taxes, then Miss Blair should be back in the house. That's my position.
Is anybody paying the utilities?
Your Honor, may I speak?
Yeah, I've been.
Yes.
Okay.
So let me
yeah,
ask this. Let me
Go
ask
ahead.
that question first. Mr. O'Donnell, do you know if utilities are being paid?
Yes, Your Honor, they've been paid every single month for both gas and electricity, and they state and they show that they're up to like 147 a month. So that house is
All right,
running
and
any
the
other house.
utilities are paid by you?
They have been paid by Miss Blair in
No, they
occasion.
haven't.
No, absolutely not. I have paid them every month.
Just a minute,
since-
just a minute.
No, that's not that.
We're not sitting around the kitchen table. We're at a
You're
court
right.
hearing, and so I'll give you a chance to speak. So, all right, who is paying the utilities?
I have been paying them.
Say that again?
I have been paying the gas and the electric every single month.
All right. Each month?
Every single month. They've been paid up to full. They've been paid this month.
All right. All right, Mr. O'Donnell, you wanted to speak. What do you want to say?
Well, I mean, regarding Mr. Solstice's just blatant misrepresentation of facts, I mean, this is the third time, Your Honor, he's done this. This is harassment. He, in his order to you for contempt, he said that we didn't pay May, June.
Could you speak more clearly into the, when you
Oh, I'm
turn your
sorry.
head,
Oh, I'm sorry.
All
Oh, I'm
right.
sorry, Your Honor. In his complaint under number 2, Mr. Solstice claims that we only made $1,000 payment in September of 2025, which he also told Judge Stutz, just trying to make us look bad. And then he says, count 3, May 25th we didn't pay, June we didn't pay, July we didn't pay, August we didn't pay, October we didn't pay, 8 months. Your Honor, I tried sending all this stuff to you, but I can't get it in the right PDF. I have the files from your paid July, June, July,
Your audio
August,
is very
September.
poor,
I got them all right here.
Mr. O'Donnell, So do you
Oh, I'm
contend
sorry.
that you
We
paid all
we
those
paid
escrow payments?
up until like 3 months ago. Yes, or 4 months ago, whatever it was. We paid the first 5,000 a month. We paid the first 5 months. I have the orders right here.
All right. So then November,
And
December,
then
January, February haven't been made?
no, not since we lost Dan Hatch. I have our hardships in there, and then we
Say that
tried,
again?
getting some. I said we lost our. Is there a way for me to turn up my volume?
Well,
We
your
lost.
bandwidth
That's
is
when we
not
ran into our.
right.
Oh, okay. Well, that's when we lost Dan Hatch, and then Mr. Under that stuff, we just got our
All right, you
discovery.
lost who? Dan Ash?
Hatch, our counsel, he
Oh,
withdrew.
yes, okay.
You let him
Daniel
go,
Hatch.
and then that's when the our hardship occurred, and we were scrambling to find somebody else to represent us in our circuit court case. And ever since then, we've been harassed by Mr. Solstice, where Judge Stutzman even gave us a 2-week relief and told us that he would give us another 2 weeks if we needed it, because he knew how much stuff I'm going through. I spent 40 hours this week, 30 hours last week, and I'm barely even into this, Your Honor. And now that I've found all this, I have a home inspection report from May 5th, right after you let us go back into that house after Rosemary got it for one winter and destroyed it, which cost $20,000 in damage.
Again, I can't hear you very well. Your signal keeps cutting out.
We paid Miss Hawes $20,000 in damage the last time she got to watch the house for a winter. Every pipe froze. We had to cut out every wall, and we had to put in a new furnace because she had a faulty, and a new water heater as well. And we have put so much money in this house. I also had a home inspection done on May 5th of 2023, right after you let us go back into the house. And that shows the condition of everything outside and everything else. That house now is in actual better condition than it was when she left it to us the last time after the winter. And we are there, and I'm there at least once every 2 weeks. And I did put in the dock this summer, and I was up there with my kids. And the house is crappy on the outside, but it was like that when we originally went to purchase it. The house is from the 80s, and they haven't done anything. I mean, it's lipstick on a pig. But I spoke with a couple realtors, and they said there's no value really in the home anymore because it's stigmatized. Because Miss Blair has put this thing on the market, I called 2 different realtors that she'd already used. They're all like, no way we're touching that property. She's used every realtor here in town, relisted it, and she's been pulling this grift forever. And then they told me that the neighbors, Fishman, just put up a huge house that basically, almost blocks half the view, so for us to maintain possession, for her to get back possession would be ridiculous. But for her to even ask for that after the damage she did last time, and then, Your Honor, I don't know if you can hear me, but I tried emailing this to you. I don't know if it came through, but I had an exhibit thing for you guys that has basically, she has right now $180,000 on this property currently owed. 170 or 54,000, I believe, of it is a federal income tax lien, and the other one, the state lien, is for like 40-some thousand dollars. And the title company that I had pulled this, we were just going to try to get financing, maybe work a deal where we could just close this out. So there's no way that you could even close on this property until she takes care of that. So the property taxes at this point aren't the big issue. It's not going to be foreclosed on in the near, like right now. However, her income taxes, the title is just dead without her income or their personal income taxes being done. And then, Your Honor, can you hear me? I have just one more thing, Your Honor. Are you there?
Barely.
Okay, and then my last thing is that us being called in here today again and having to go through this is we just found out new discovery like last week that Doug Coleman, who was the original guy that Rosemary conspired with to like condemn us, kick us out, there was FOIA things that they hid for a while that just were released. We found on the Fabius Township thing, and our name was in there. And Doug Coleman last year in May went to the village attorney trying to have us condemned and kicked out again for a sequestering order or something to get us kicked out.
I'm not aware of that.
He's out of control. It's in. I can send you a copy of the FOIA, and he made several. So so there's something to know about that. So I wanted to make sure that that's not on
You
record.
sound
We're not
like
trying to
Charlie
evict us again
Brown's
illegally.
teacher. I get about every 4th word. It's,
Oh, man.
you've got not much bandwidth, and so it's hard to hear everything. I was
Can I try from my
aware,
phone, Your Honor?
excuse me?
Can I try to log in from my phone real quick, see if I can get a better
Yes,
signal?
you can. We might get feedback if you're logged in from two different devices.
I'm running. Zooming me down. One second. Did you see it, Mr. Your Honor? Yeah, Your Honor, it's showing me recording.
Your Honor, are you able to?
Can you hear us, Your Honor?
All right, let's bring them in, see if we can hear it. We might get a feedback. All right. Just set your phone down.
Your Honor, do you have me in a breakout room?
No, I don't. I have you in my room. I can hear you better now that your phone is on. So let's try this method. I can see you and your phone. I think I'm hearing you through your phone. So you were talking
I was at
about,
the point where in this motion, I was discussing Miss Blair the last time she took possession and how it caused us almost $20,000 in damage for the 6 months or 8 months she was watching it over the winter. We
now
keep the
that
heat
was
on.
the winter of 23.
Yep, because it was May of 20, or yeah, it was May of 23 when we got back in there and I had the home inspection done.
All right.
and
So,
he detailed everything. But I also, for our hardship, I mean, we lost, Dan Hatch here, and Mr. Solstice keeps on referring to us missing these deadlines and this and that. We didn't receive until our discovery from Butzel until this Monday that I had access to, and then the next day we received I have to be in Grand Rapids next week because they're going to put liens against all my stuff, which of course, Butzel swore to us that this is an unlosable case, and they swore to us that they'd wait till after
all
this
right,
case
so
ended,
you're also
come
being
after
sued by Butzel Long for fees?
Yeah, well, he actually froze my bank account, which is, I mean, talk about a place that overpromises, overcharges and underdelivers. And then they froze my bank account. So I mean, my hands are tied right here, and it's ridiculous that we're going through this right now. We're working our best. We're going to secure the property.
No, it's not. We need to find a resolution for this.
We've been trying, Your Honor, for 3 years.
I'm sorry. I agree 100%. This house needs to be sold. I ruled in your favor. One of your problems is you hired Bechtel Corporation to come in and put in your septic system when you really need to hire Joe's Septic Service, a local company, to come in and do it. I don't know how much your legal fees were from Butzel Long, but I'm sure they were substantial. They've withdrawn as your counsel. Now they're suing you, which doesn't help any of this at all because you need money to maintain this house.
So could you put, Your Honor, could I ask you to help me out with this and put a stay on that until the end of this thing? I mean, he told me.
No, I don't have the authority to do that. I'm not even sure what they've done. I regret to hear it, but this is a mess. And there's enough frustration to go around right from the very first day you got pulled out of your bed. Mr. Soltis is the fourth attorney that Miss Blair has had, and he's done by far the best job so far. He's trying to get this to the finish line too, but you're not paying the taxes. You're not paying the escrow. The house is sitting there. I don't know who's in it, what's going on with it. I've heard it's fallen apart. I haven't been out there to look at it. And the world has changed. Mr. Soltis is late to this, but the purchase price was $425,000, which seemed like a significant price. At that time, the market was hot, interest rates were low, and that house probably could have been sold for
it needs all new windows, Your Honor. That's $200,000.
$650,000. The house was worth more than your contract to purchase it at the time. As I said, that was not an unfair price. It was a negotiated price. I ruled in your favor for the sale of the home. But at that time, in my opinion, the home was worth more than that, maybe significantly more. Now, circumstances have changed. Somebody's built a house adjacent, blocked part of the view. The house has been unkempt for several years. It's subject to this messy lawsuit. It's got 2 tax liens on it. I don't know what it's worth now, $1. It's different. You wish to execute the purchase of the home, and so does she. What she wanted to do. The problem is the circuit court needs to determine what your damages are. Mr. Hatch filed all these actions in circuit court that some of the things I lacked jurisdiction on, more than $25,000 in damages. I lost control of it and went to circuit court. And I don't know exactly what's happened since, although some of the pleadings talk about how long the delay is. Now, apparently there's some sort of hearing in June. But right now it's going to get foreclosed on. And that is not in anybody's interest. That ultimately may happen to this, but I don't know who would bid on a house that has $220,000 worth of tax liens on it. And
Your Honor, with the
And-
realtors I met with the two of them I spoke with local and the specialist. I mean, they told me at this point, the house has been stigmatized by Miss Blair. Before this event even happened, they said this even made it worse. They said that no one would touch that property, and that they said basically it's a lot value almost right now at 400,000 unless someone wants to come in there, because it's a minimum 250 to get that place back going to normal. And it needed
what do you want me to do?
150, 200 when we bought
Soltis
it. That's why
wants
we got the
me,
deal.
Mr. Soltis wants me to give them possession of the premises back, and he wants me to order you to pay the escrow, and he wants me to allow to use what escrow funds we have to pay the 2024 taxes.
Yeah, but he based that on misrepresenting the facts, Your Honor, about everything. I mean, he bases
what do
all that
you
on
want?
misrepresentation. He skips over the fact that she destroyed the place the last time she had control of it. I mean, she
All
caused
right,
so
well,
much.
I'm not prepared to give the house back to her. When she had it, it froze. All the pipes broke. The drywall had to be redone. The furnace was ruined. I don't want to do that again. And now I haven't put you under oath, but you and Ms. Bowers both represented that the utilities are be paying each month. It's wonder the house hasn't, well, I won't even say it. So there it is, sitting there pending circuit court. Now, you're not in small claims court, you're in circuit court and district court. And there are rules of procedure and rules of evidence that have to be followed. You don't have a lawyer. I'm not being critical. I don't expect you to know this stuff. It's complicated even for me, but you're not following the rules in the circuit court where they're trying to get the matter ready for trial. I would not be surprised if this matter.
We're trying
If
in
this
good faith.
matter
We didn't
isn't-
have the documents.
Will you
Hutzel
stop
never gave us-
interrupting me?
Oh, sorry, Your Honor.
That's one thing. You haven't heard Mr. Soltis do it once. Attorneys are much better at following the decorum in the courtroom than lay people are. I'll give you a chance to speak. I don't want to just blurt stuff out. So you want me to just go away, essentially, and maintain the status quo of further dilapidation of this property.
Are you talking to me?
All right. So what do you want me to do?
Right now, Your Honor, I mean, I think that like this is harassment by Mr. Solstice, because he's been bringing up, I mean, he's been misrepresenting everything about the property. I mean, he's been saying we haven't been there, we've been destroying it.
Well, I didn't ask you that. I don't think it's harassment. I think it's
what I want to
legitimate
do, Your Honor,
representation of his client. But
I
let
don't know
me
if
ask
there's any way
you
you could-
again,
could you order?
what do you want me
could
to
you-
do?
Oh, I'm sorry. Could you make an order that she pays off her tax lien, and then we get clean title, and then we'll purchase the property, put whatever money it is into escrow, and then once the circuit courts figure it out, then it comes back down to you, and you just figure out which way it goes from the escrow.
Well, I'm not sure I even have the authority to do that, but at some point that tax lien is going to be paid off, presumably with presumptions of the sale. But let's say,
That's all of our money, though, Your Honor. So we're paying it out of our own pocket. We'd be saving $6,000 a month if I could get it in my name now, or not a month. I'm sorry, a year. So that's what we pay for out of state, because I can claim that as my primary.
so you want me to order her to pay off her tax liens
Yes.
and clear title to the property, and then do what? Not order that you pay any escrow pending the
No, then we would,
disposition?
yeah, once that's done, and then we would just follow through, because then I could get something, and then all the money would just go into escrow. Once I had a clean title, I could get the money, whether I have to borrow it from the bank or private, whatever I do. I mean, get the money, and that's not an issue. I mean, but it is. I mean, I'm under serious financial hardships, but I make, okay money, so I'll get by. But I mean, and at this point, we don't know if we have the money to even redo the
Well,
house.
for
or
one
dream
thing,
that.
what you told me isn't evidence. It's hearsay. I don't know. I'm assuming that there's some kernel of truth in it, because I'd heard it before, that there are 2 tax liens on the property. I haven't seen any evidence to that, but let's assume for the sake of argument that that's true. You can't borrow any money to buy this house. No lender would lend you a house that you can't get title to. But in the meantime, no one's paying the taxes. I'd have just let you all go, let the house go to foreclosure and have somebody buy it at a tax sale. But that's not effective. I cut your escrow payment in half. I allowed all the escrow money to be used to pay the taxes, which I thought was a legitimate use of it. I cut your escrow payment from $2,000 a month to $1,000 a month. You paid some, now no one's under oath. Mr. Soltis represents you paid one. You represent you paid five, and there are 4 or 5 unpaid at this time. But as of at least November, they're not being paid at all. And
But that's not a disrespect, Your Honor.
well, I don't think you did it to, poke me in the eye. I think you've got financial issues. And in the meantime, you're being sued by your earlier lawyer.
This is the legal turning point. When a judge orders escrow payments, it's not optional. It's a protective measure. Escrow in property disputes acts like neutral ground. The money sits with the court until ownership and damages are resolved. Here, the judge reduced payments from $2,000 to $1,000 a month, a significant accommodation. But once payments stopped in November, that technically becomes contempt. Now notice something important. The judge doesn't believe this was done out of spite. He believes it was financial hardship. But hardship doesn't automatically cancel a court order. That's why he keeps asking, what's the effectiveness of my order if you don't comply? This is where self-representation becomes dangerous. If you can't meet an order, you must formally request relief. You don't just stop paying.
Your earlier lawyer, who's that doesn't help at all.
No, I mean,
All right.
Butzel, I would not recommend them to anybody in the world. They're terrible.
Well, I don't know what to say about that. It's got a fine reputation, but it was more of a lawyer than you needed. And my example is using a multinational construction company to do a local construction job. Plus the wheels fell off when it got stalled in circuit court. I made a ruling regarding the personal property, boats and wave runners and skis and that sort of thing. And Judge Stutzman overruled it. Mr. Hatch maintains there's a statute, which there is, which allows district courts to deal with personal property in certain circumstances, but his ruling was different to that. But we have to do something. I ordered that you pay $1,000 a month, and you're not paying $1,000 a month. That's called contempt. It's not harassment.
Your Honor?
Yes.
I mean, I don't know how to talk about a hardship here, but like what has happened in this case, you normally say the truth is in the middle somewhere. No, not in this case. It really isn't. And it's just all on her. But we spend at least $300 to $400 a month in the house just to carry it right now, just for the utilities and whatever. And that's literally every month. So that is always being paid. The property's always being, swept up, whatever. But for this hardship right now, I was expecting this to close or for them to settle this out at some point.
What you're
until
doing
we figured
right
out that
now,
she can't afford to do anything. If she
The
really
judge
took-
cuts through all the side arguments, the frozen pipes, the furnace, the realtors, the alleged conspiracy, and brings it back to one simple legal fact. The deed is still in her name. In property law, possession and ownership are not the same thing. Even if they've invested money, even if they've maintained utilities, legally, title controls. And here's the hard truth. If you occupy someone else's property while ownership is disputed, courts often require payment into escrow as a substitute for rent. That's what the $1,000 represented. Now the judge is balancing equity. He doesn't want foreclosure, but he also can't ignore unpaid taxes. This is what civil litigation looks like after years of delay. Value decreases, liens increase, and everyone loses leverage.
do anything. If she took possession of the house, Your Honor, she can't even afford the gas bill. So, I mean, I don't see what that accomplishes. And with all the neighbors who we've proven of conspiring against us, and Doug Coleman trying to get us evicted again last year behind your back, I think. Because how else?
Well,
I
he's
never even heard of
retired,
a
so he's
equestrian
he's
order.
gone off to other things, but all right. Essentially, you're living in her house without paying any rent. It's not your house, it's not her house. She has the deed, she has the title, it's her house.
What about the new
So,
furnace, Your
and
Honor?
when people, excuse me?
The new furnace, wouldn't that, I mean, the 20,000, wouldn't that be considered putting money into the house? Did she never put, I mean, we had to put a new furnace in there because she didn't, I mean, we've been doing everything. We've got almost 300,000 total into this house already, cash. And that's, 100,000 to Dan and those guys at Butzel. That's another 120 to Rosemary. That's another, 20 something in the furnace and stuff. And then we got another 20. I mean, it's just the numbers are just astronomical. And then we paid you guys another 40 in escrow. And then they're telling us we have to pay taxes that doubled because it's not in our name and that she should have been paying. And then we find out she's got a $200,000 federal tax lien on her that we didn't know about. I mean, my gosh. I mean, that's why I fell over in the beginning of this case. And then they lied again and misrepresented you that she had taken care of that twice in the last, I don't know if Mr. Solstice was there, but one of her attorneys did. And then you were under the belief that she covered all that and it was all good and happy. And now it's like, I mean, everything I read through is just, none of this is factually accurate. I mean, half of the stuff that Mr. Solstice files is just, I don't know what, he's just throwing stuff at the air. That's why I feel like it's like, he's constantly coming after us. The other judge said, he's like, they're going to need an extra 2 weeks. I'm going to give it to him. And now he's coming here telling you, well, no, he said, no, that's not what he said.
Your Honor, I respectfully but vehemently disagree. Judge Stutzman said, based upon Mr. O'Donnell's promise on January 29th, that he would get me those answers to interrogatories and documents on or before February 6th. Now, if he says 2 weeks, we're at 2 weeks now and I still don't have them. Mr. O'Donnell, I don't believe is very credible. And so, we're going to sort that out if we can eventually get the discovery that I'm asking for.
You tell me about your bill for you talk for a second.
Mr. O'Donnell, you're in the big leagues. You're in a circuit court case. I guess it'd be bigger as a federal. And there are rules you're supposed to follow. If you had a lawyer, Mr. Hatch was still in the case, he would have answered the interrogatories in a timely manner. But you're trying to practice law without a law license, and that's not easy to do. Mr. Soltis is representing his client. He'd also like to get this property sold, and it's in limbo.
I've reached out to him 3 times. He's never contacted me back.
All right. Now, I started to make this point earlier. You have possession of the house presently, essentially for utilities. When there's a dispute regarding ownership of property, the judge has the right to order that the payment be made into escrow. And the court holds on to that money till it's determined who was right or wrong. What I had hoped is ultimately these escrow funds could be applied to the purchase price that was finally determined to be, well, first of all, there's damages. You've got a claim for damages. And at some point, I was hoping your purchase price was, I don't know, $425,000 less 135 or something plus the escrow. So you owe several $100,000 to complete the purchase agreement. And my hope was the escrow funds could be used ultimately to be paid toward the purchase agreement. In the meantime,
Your Honor,
the
the original.
taxes continue. Stop interrupting me. The taxes continue to accrue. This is a non-homestead parcel of property. Taxes are very expensive. It was a valuable piece of property. And so there's a big tax bill. And I used the first portion of the escrow funds to pay the 2023 tax bill, which neither party was paying. If it's going to be your house, you should be responsible for the tax bill. If you think she should be responsible for the tax bill, then I guess you should pay some money for being there every month rather than just the utilities. So if you think the tax bill is hers, then I guess it's more her house than your house, and you should pay a monthly fee for staying there into escrow. If it's your house, as you contend, you should be paying the taxes. So it depends on which side of the coin you're on. But right now, nobody's paying them. And I don't think you stop paying this $1,000 a month out of spite. I think you don't have it. And then in the meantime, your bank accounts got frozen. So that doesn't do anybody any good. Mr. Soltis, do you have a sense of how much is in the escrow? I didn't look.
Well, Your Honor, I did finally today, or yesterday rather, get a copy from the court clerk. There, as far as I can best figure out, because I don't have a total there, but if you take the amount that is in there, you don't include Mrs. Blair's $5,000 that she put in there, and so forth. You have a total of $13,571.48.
You told me that earlier.
Yep.
And there's not enough to pay the 2024 and 2025 taxes.
Correct. Sufficient to pay the 24, $9,459.82, but not the 25.
Yeah, these taxes would be half though if we were paying them.
Say that again?
I said they would be half if we were paying, Your Honor, because we have a homestead, so it wouldn't be even close to this number. We're being punished, double punished, and we're still paying them out of our own escrow that we're paying into. And Rosemary still maintains the $120,000 she took from us originally. I mean, all the money's from us. Like, it's all one-sided, and we're paying for it. I paid for the boats to get fixed and out of storage, and she took them back or whatever. I'm so like, it's just, we need to come to like, she needs to pay off her federal tax liens. Then we need to have clear title, and then we need to just figure out either close this. The dam's trial starts in June. We'll get through that. Hopefully by July that'll be over, and then bam, we're done.
I doubt that.
Well, I wish it were as simple as that. All right, how do you respond to Mr. Soltis's claim that I cut the escrow funds in half, ordered you to continue to pay at $1,000 a month, and you just stopped? So what is the effectiveness of my order if you don't comply with it because either you don't feel like it or you don't have the ability to comply with it? How do you respond to that?
Well, I respond that it was in, it wasn't not in bad faith at all, and it was due to an extreme hardship. And at that time, Your Honor, I didn't even make a payment on anything because I was frozen in time because we got slammed with everything at one time. And it all started coming down. And then we kept on getting this new, this, that. We'd get here, then I'd get another order to go in front of you. So every time I'm preparing for you, then I get another order to go back in front of. So, we're working with, two hands tied behind my back. I'm trying my best here, and I'm getting caught up. I got all the software. I got a computer now, figuring out how to get these pictures into PDFs. And then this is all going to flow a lot smoother, Your Honor. However, we've put way too much in that property. And now in the next couple of months, I got to put a bunch more money in there because I got to go up and, work on the roof again. And I got to do all the other spring maintenance up there. And I know she would never do that. And I don't have a choice. I have to do that because without that, then the house really does fall apart. But the home inspection I have from 2023 will show you how destroyed the exterior. I'm just talking the interior of the house is like, it's got
I remember all of that evidence.
And that was right after she'd left it. But now if I showed you, I downloaded them. I couldn't get them to upload to you, but I have the new pictures from last week when I was there that show new furnace, new hot water heater, nice hot place. The inside's clean, like it's all. The outside though, it's going to look like that for a little while. There's not much you can do unless you tear that stuff down. It's not you can just throw like paint over it. And the guy said that the house needs all new windows. The two of the realtors went through there said all new windows. That's why they said it's pretty much lot value.
I haven't
What are her
objected
plans
to
if she
all
does
this hearsay, Your Honor. I mean, I
Yes.
don't believe Mr. O'Donnell at all. So,
Well, he's
But
the only
I'm
one that's
not-
been lying.
I'm not going to argue in front of you about hearsay. Thank you.
Yes.
Where's she going?
Well, there's a trial set, and I regret that it's not set till next June. In fact, I'd be surprised if it even goes then. But I hope it does.
Your Honor, right now, I mean, we need a little bit of a lifeline here, and I think we deserve one. After what we were put through, and you witnessed it in your courtroom on the multiple times that you let her go on contempt for nothing, and in 3 different times, fake doctor's notes, all that stuff, and now this one time, like we're really trying, and we're in a bad spot here. But I mean, we've been at this for a long time, and we've just gotten really run over, and now they're really putting a full court press on us, and we're doing our best, and we're willing, we're going to work through this. We'll be fine. We're just asking for some relief here just to get through, just till we can get this darn trial. I mean, it's like we were promised one thing, and that, if they withdrew from it, they promised they'd never leave us.
Your Honor,
Yes.
when Miss Blair apparently didn't show up for 2 depositions, which I believe weren't properly noticed or weren't able to be properly
Oh.
noticed, you held her in contempt $5,000. She paid it.
That was her original.
That was what contempt was it, like the 5th?
All right. Mr. Soltis, it's your motion. I'll give you the final word.
Yes, Your Honor, thank you. I guess what you're saying is you won't return Miss Blair to the owner to possession of the house. And if you won't do that, then let's move on to the money aspect of it. Tax for 2024 to avoid this house going into foreclosure, tax sale, $9,459.82. There's escrow at least. I have 5 months counting February of $1,000 a month, $5,000 that has not been paid. Miss Blair is having to pay me to ride herd on these people because they don't do what you've ordered to do. And I think that entitles me and her to have cost and attorney's fees.
Why, 'cause she's not paying me either.
All right. I am going to order that the existing escrow funds may be released to pay the 2024 taxes.
It's just our money.
And she wants to go back and live there.
I decline to relinquish possession of the property to Miss Blair because of what happened previously. I am going to allow costs and attorney fees for this motion. Do you have a bill of costs yet, or?
Not put together completely,
All
Your
right, I'll
Honor.
ask you to submit a bill of costs and fees with the order.
Your
I'm gonna lift the escrow requirement. And I'm gonna excuse any currently unpaid escrow funds. I do believe there are 2 significant tax liens on this property, which may ultimately affect Mr. Bowers and Ms. Bowers, Mr. O'Donnell's ability to even purchase it. So far, we've just been paying this money into escrow and I've been using it to pay the taxes. I guess if they're not gonna be worried about the taxes, maybe I won't. But we'll get the 2024 taxes paid and they can get through 25. I would give you about a 50-50 chance of having this case tried in June, but I'm hopeful that it would go and there would be a resolution. Mr. O'Donnell, you're acting as your own lawyer. You've got a bunch of complicated claims. You've got money damage claims. You've got specific performance claims. You've got equitable claims that are only have jurisdiction of the circuit court. On the other side is Mr. Soltis, who's got 45 years of legal practice representing cases like this. And he's got to be much better and much more adept at representing his client at that damage hearing. You're not just going to show up and say, hey, she owes me all this money. Right now, you can't afford to hire a lawyer. Your previous lawyer is suing you for a large sum of money. The case is an absolute mess. I appreciate Mr. Soltis getting into it in the posture it was in. But I'm not going to order you continue to pay $1,000. I'm going to use the money I've got to pay the taxes. Mr. Soltis isn't harassing you. He's representing his client. And you stopped complying with my order that ordered you to pay $1,000 a month. So his client's calling him up and saying he's not paying the escrow payments. So he's got an obligation to his client. That's on you. Well, I just excuse your obligation to pay the escrow. So you're to continue to pay the utilities and otherwise maintain the property. Put that in the order, Mr. Soltis. The defendant shall continue to pay utilities and otherwise maintain the property.
Then, Your Honor. Thank you.
You're also going to pay Mr. Soltis's cost for bringing this hearing. I don't know what it is. It'll probably be several $1,000s. But he's just doing his job.
Your Honor.
But you're going to be in front of Judge Stutzman again next week. What he's doing is discovery, which is what people do when they're involved in litigation. He wants to know what he needs to know to represent his client.
My biggest
property had been sold back in 2023. Everybody could have been made whole. It would have had a fairly high sale price, or you could have purchased it. She could have got
Your Honor,
some equity out of it, and but now it's just a dissipated valuable
She's had this
asset.
lien on here the whole time. We never would have been able to purchase it.
but Your Honor, my last thing about Mr.
Well,
Soltis.
let's say you gave her $400,000 for this house and she had a $220,000 lien.
It would be taken
Well,
off at closing.
$220,000 would go to pay off the lien and she would get $180,000. So there was some equity in there for her. The problem becomes if the tax lien exceeds the value of the house. At that time, it did not. You had a purchase price at what was at that time a fair but favorable to you price. I'm no real estate appraiser, but I do know that property was very valuable at that time. Interest rates were about 1%. It was a nice home at a favorable location on a wonderful inland lake. But now it's different for a bunch of reasons. All right, so let me recap. I'm going to allow $9,459.82. No, that was 24 taxes. 945982. 25 taxes will remain unpaid. The escrow funds may pay the tax. I'm relieving your obligation to continue to pay escrow, and I've forgiven the payments you didn't make. But I am ordering to pay Mr. Soltis's costs and attorney fees for bringing this action. He's going to prepare an order and send it to me under something called the 7-day rule. You'll get a copy of it and you have 7 days to object if there's something in it you disagree with what I said. Other than that, I'll sign it and we'll allow that escrow money to be transferred over so the property doesn't get foreclosed on. Now, the problem with that is I'm spending that money on taxes, but I don't want the property to get foreclosed on. There may be an issue about whether you get credit for that at the time if that's taken off the purchase price of the house. Because right now, all the escrow money was gonna be applied to whatever was left on your purchase agreement. So in rough figures, it was $425,000 and you paid about $135,000. So that's a little less than $300,000. If you paid $50,000 in escrow, I would have allowed that money to be applied toward the purchase of the house. I'm making these rulings where I'm using tens of thousands of dollars of escrow funds to pay the taxes. That matter at some point is going to have to be resolved. But for now, that's my ruling. You still could benefit from some legal advice. I don't know who would want to get in this case. I understand you're a layperson. You're doing the best you can. You're in an untenable circumstance, but you can't just throw your hands up and ignore my order. So now we have a new order. If you don't pay Mr. Soltis's cost, there'll be another contempt hearing and there'll be another cost. And you guys can see Judge Stutzman on your discovery issues next week. But that's an order too. He told you that he gave you a deadline, you didn't meet it. He gave you a 2-week extension, you didn't meet it. You're gonna have
It was
to,
an
at some
impossibility, Your Honor. We just got the files on Monday. From the butts alone,
well,
we just
explain
got
it,
the files on
explain it to
Monday.
him. All right, Mr. Soltis, anything further we need here?
No, Your Honor, I'll prepare the order 7-day rule.
All right, thank you.
One more question, Your Honor.
Yes.
And under the 7-day rule, I mean, just because in his, contempt order, I mean, he didn't do his homework because today he sat to you and told you a whole different story than is written down here. Counts 2, 3, 4, 5. I mean, he just changed his whole tune. So, I mean, it's like he's just submitting whatever he wants. And then he goes in there and then just, well, let me clarify. I mean, he did that in front of Judge Stutzman. So that's how I feel like I'm being like I'm just.
You're shooting at the wrong target. I just gave you a huge bunch of consideration and you're complaining because you don't understand the pleadings. You're going to get blown out of the water in the circuit court unless you figure out what you're doing. But
the judge orders the escrow funds, roughly $9,459, to be released to pay the 2024 taxes, preventing immediate foreclosure. He refuses to give possession back to the original owner due to prior damage concerns. He lifts the future escrow requirement and forgives unpaid escrow, but orders the defendants to pay attorneys' fees for this motion. In other words, partial relief, but not a free pass. The court acknowledges hardship, but reinforces authority. Orders matter. Discovery deadlines matter. And representing yourself in complex circuit court litigation against a 45-year veteran attorney, that's a dangerous gamble. This case is a masterclass in what happens when financial strain, legal delay, and procedural missteps collide.
But I don't want to hear it. You pay his fees.
That's fine.
All right, you're good to go.
Thank you, Your Honor.
Thank you. All right. In the meantime, they've been working on Pine Valley versus Stroop. It appears they've been in and out of the courtroom several times. I'm going to stop the live feed, make some notes regarding this hearing we just had, see where we are on the infamous bed bug case.